this or not, but let's try. I want to follow up on a question that Senator Specter asked about admissibility of evidence in deciding which forum you would try these defendants. Is it your position that it's going to be easier to get evidence of their guilt in an Article III court than it would be in a military commission?
I'm not sure I view it that way, as opposed to what evidence would be used in the Article III courts in connection with the cases that I've already made the determination should go there, as opposed to what the way in which the military prosecutors wanted to conduct the case.
Well, surely you wouldn't decide in your discretion to try a case in a tribunal where it would be harder to get a conviction, would you?
No, I mean, what I take into account are all of the factors that that are a part of the protocol.
You mentioned the marshal's report on the potential venues where this case could be tried, and as you noted, a judge could, contrary to your wishes, contrary to my wishes, transfer it to another venue other than New York City. Based on the marshal's report, what other venues are you prepared to try this case?
Well, I asked the marshals not to look at the entirety of the United States, but really just to look at 2 districts and the courthouses in 2 districts, and to make a determination as to where in those 2 districts the case could be best tried. And so
where was the other one?
I looked at the Eastern District of Virginia as well as the Southern District of New York.
And those are the only 2?
Those are the 2 I asked the Marshal Service to look at.
When the detainees come to the United States, will they have some immigration status?
I am not an immigration expert. I do not know what their status might be. I am confident, however, that given the fact that they would be here under the supervision of, and as a result of their being charged in a federal court, that we would be able to detain them, that we would be able to hold them as we would do anybody who was charged with such serious crimes.
Are you aware of any bar to their ability to claim asylum or argue that they should not be removed from the U.S. because of the Convention Against Torture?
Again, I'm not an immigration expert. One can be paroled into the United States solely for this purpose, but there is no right to be here after. I can't imagine a situation in which these people would be paroled into the United States for that purpose.
So is it your position they will not be conferred rights that they did not previously have by virtue of their coming to the United States?
That is my belief, but again, I am not an immigration expert. I am confident my expertise deals more on the Department of Justice side, and I'm confident that on that side we can detain them safely and prevent them from ever walking the streets of the United States.
I understand we can't all be an expert in everything, and the law is complicated, but will you acknowledge that it's possible, or let me ask you if you look into it, whether if a detainee claims an immigration status by virtue of their presence on U.S. soil, it will allow them to immediately trigger tandem administrative and federal judicial immigration proceedings. Will you look into that?
Okay, I can look into that, because I would not be able to answer that question.
And if the detainee is acquitted, or there's a mistrial, let's say one juror decides to hang up this jury, on what basis do you believe that you could permanently detain Khalid Sheikh Mohammed or any other of the 9/11 detainees? Is that on the basis of a Supreme Court decision, on the basis of a statute that Congress has passed? What's the foundation of that belief?
Well, the initial determination that a judge would make for the detention of Khalid Sheikh Mohammed would be one that would last beyond a mistrial. If, for instance, there were a trial and a determination made, a hung jury, we would, I suppose, the defense could move to have his bail detention, his detention status change. It's hard for me to imagine that a judge, having heard the evidence and making that initial determination, as I'm confident a judge would, to hold him, seeing that he is a danger and flight risk, would then change that status of Khalid Sheikh Mohammed between the time of a hung jury and the next trial.
I believe the Supreme Court has held that you cannot indefinitely detain somebody unless under the Zavidas case. But let me just ask, final question. Are you concerned that a judge may say you've made an election to try these terrorists as a criminal, and you're bound by that election, and you cannot go back and revert to the laws of war in order to claim that you can indefinitely detain that individual? Are you worried about that?
No, I'm not. I think that under the congressional provisions that we have, and the laws of war, that we have an ability to, you cannot perhaps indefinitely detain somebody, but you certainly can detain somebody for lawful reasons. Again, I don't think that we're going to be facing that possibility. We're talking about very extreme hypotheticals, I believe, based on my understanding of the evidence and the law and the ability of our prosecutors to present a very strong case.
I hope you're right.
Thank you very much, Senator Cornyn. And